Good afternoon, and thank you for joining us today for our talk, which is on the equity of exoneration and other equitable relief in the context of personal bankruptcy and real property. I'm Jamie Hannant, this is Jennifer Edwards, and we are both members of Guildhall Chambers' Insolvency team. In terms of a structure for today, I'm going to introduce the history to the doctrine of the equity of exoneration. Jennifer is going to speak to the development of the principle and its modern application, and then I'm going to look at other equitable relief in the form of equitable accounting and the ability of a trustee to charge an occupation rent. The vesting of the family home and any portfolio property in the trustee in bankruptcy upon the making of a bankruptcy order gives rise to a frequent source of litigation familiar to all who have practiced in the insolvency jurisdiction. The logic of section 306 of the Act is that all of the property, including real property, vests in the trustee upon their appointment and does so without any conveyance, assignment or transfer. However, this raises the question of what exactly is the bankrupt's property, and it is in relation to this particular issue that the battleground usually lies. The informality of the arrangements which exist between married couples means that the role of equity has particular prominence in disputes which arise in relation to the bankrupt's family home. The reliance on the common intention constructive trust, proprietary estoppel, and less frequently resulting trusts will be familiar to all. However, this talk is focused on two less frequently relied upon equitable defences, namely the equity of exoneration and the principles of equitable accounting. Although it might not be necessary to understand the deep history of the jurisdiction to deploy the relevant principles, it is interesting to note the origins of the equity of exoneration. During the early to mid-19th century, the answer to the question of what property was held by the bankrupt and that held by the bankrupt spouse was, at least on the face of it, straightforward. The married couple's property was in fact that of the husband alone under the doctrine of coverture, as described by William Blackstone in his commentaries on the laws of England in the late 18th century. And what he said was that by marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband, under whose wing, protection and cover she performs everything. To modernise, those words are perhaps surprising, and by the latter part of the 19th century, Parliament began to intervene with the passage of the successive Married Women's Property Acts. However, before Parliament's intervention, the courts of equity stepped in to provide some assistance to the wife. Early 18th century examples of equity intervening to avert the injustice which would otherwise prevail include the following decisions. First of all, we have Pocock and Lee. It's a case from 1707, where a husband and wife joined together to obtain a mortgage secured over property, with the equity of redemption reserved to the husband, wife, and their heirs. The husband having died, the Court of Equity held that the mortgage fell to be discharged out of the husband's share of the estate and in exoneration of the interest of the wife. A second example from around the same time, 1702, is the decision in Earl of Huntingdon and Countess Dowager Huntingdon. In that case, a wife and husband joined together to mortgage various properties which made up the wife's inheritance. The husband discharged the mortgage debt and took an assignment of the mortgage, which was held in trust and for his benefit. Upon the passing of the husband and the wife's son and heir successfully asserted a beneficial interest in the estate as against the heir of the husband. Both are early examples of what was to become the equity of exoneration. Although it is hard to discern a coherent rationale for the doctrine from those early decisions, by 1985, the parameters of the equity had started to crystallise, with Mr. Justice Scott setting out the ambit of the principle in the important case of Reed Pitt 2. And what he had to say was that, as a general proposition, if there is found to be a charge on property jointly owned to secure the debts of one only of the joint owners, The other joint owner, being in the position of surety, is entitled, as between the two joint owners, to have the secured indebtedness discharged, so far as possible, out of the equitable interest of the debtor. Put another way, where property jointly owned by A and B is charged to secure the debts of B only, A is, or may be entitled to, a charge over B's share of the property to the extent that B's debts are paid out of A's share. Now, in Re Pittitu, this was a case where Mr. Pittitu took over the running of a family restaurant in 1972. A charge was given by Mr. Pittitu and his wife to secure the indebtedness on an account which was to be used for, amongst other things, the purposes of the restaurant business. In addition to those purposes, the account was also used for the purpose of discharging household expenses, as well as supporting the establishment of a woman for whom Mr. Pittitu left his wife prior to the married couple's eventual divorce. Following Mr. Pittitu being declared bankrupt, his trustee in bankruptcy issued an application for a declaration that he and the former wife were each beneficially entitled to 1/2 share in the equity. In giving judgment, Mr. Justice Scott observed that Mrs. Pittitu was in the position of a surety so far as her own proprietary interest in the property was concerned. The bank's charge was therefore a charge to secure her husband's indebtedness and not her own, but that indebtedness was secured on property of which she in part was the beneficial owner. As such, she was entitled to an indemnity in respect of the debt created by her former husband's borrowing, but if that was only a personal right, it would be all but worthless, given her husband's bankruptcy. However, the effect of the equity of exoneration would be to confer or enhance the wife's proprietary interest in the property. As was explained by Mr. Justice Scott, it is, I think, clear that the effect of the equity of exoneration in a case such as this is indeed to enhance the proprietary interest of the surety, and not simply to give the surety a personal right to an indemnity from the debtor, who is the other joint mortgagor. Scott J. went on to observe that the principle was founded upon the presumed intention of the parties, with such a presumption being rebuttable. In applying this principle, the judge first observed that the family had acted as a family unit in its family and business affairs, with Mrs. Pittitu working long hours for the family business. As such, it was not possible to impute an intention that payments made by Mr. Pittitu for the family's domestic expenditure should fall solely on his share of the property. This marked a departure from earlier authority, where the presumption was that such expenditure would ordinarily be the responsibility of the husband, with those payments for which the wife was to be responsible being limited to those for the wife's exclusive benefit or in discharge of her exclusive debts. This approach is notable as an example of the equity evolving to reflect and to accommodate changing social attitudes and norms, and also indicates the capacity of the doctrine for further development. However, Scott J. went on to observe that save for those payments made for the joint benefit of the household, the equity of exoneration did not have any less part to play now than it had in the early days when the equitable doctrine was being formulated. Before concluding, the second charge, securing the debt owed to the National Westminster Bank, secured a debt of the bankrupt. The debt was not a debt of a second respondent. Prima facie, therefore, in my judgment, the equity of exoneration applies to entitle the second respondent to require that indebtedness to be met primarily out of that bankrupt share in the net proceeds of sale.
Thank you, Jamie. In 2017, the question of whether a direct or an indirect benefit could give rise to the equity of exoneration was considered in the case of Armstrong and Onyeru. Now, the facts of this case were that Mr. and Mrs. Onyeru were a married couple. Both of them were employed. He had his own solicitor's practice, and she was a lecturer. Now, of note, they both received income from their employment into separate accounts, but as a family unit, they jointly decided that they would both cover different parts of the expenditure. In particular, Mrs. Onyuru paid the bills, the household bills, and Mr. Onyuru paid the mortgage payments. Now, the family home was owned solely by Mr. Onyuru, but Mrs. Onyuru maintained that she had a beneficial half interest in the property. In 2005, Mr. Onyuru took out a loan secured against this family home to provide funds for his struggling solicitor's practice, and unfortunately in 2011 he was declared bankrupt. Now, Mrs. Onyuru argued that the equity of exoneration ought to apply as the facility in 2005 was used solely for the benefits of Mr. Onyuru's solicitor's practice. The trustee in bankruptcy argued that Mrs. Onyuru had received an indirect benefit by way of her husband's business surviving at least until 2011, and drawings from the practice being used to meet the original mortgage payments. Now, at first instance, the application was dismissed, and this was upheld on appeal by Mr. Jonathan Klein. The trustee in bankruptcy then applied for permission to appeal to the Court of Appeal, and this was granted as it was considered that an important and novel point was raised as to the application of the equity of exoneration where an indirect rather than a direct benefit had been received. Now, it was noted this was the first occasion that the matter had been discussed since Paget in 1889 in the Court of Appeal. In brief, the appellant, the trustee in bankruptcy, argued that as the loan was incurred to enable Mr. Onyuru to continue to contribute to the family home, the finding of the courts below of the presumption that the parties intended his liability to be thrown solely on his half was fundamentally inconsistent with the relationship which spouses bear or ought to bear to one another in the family affairs in current times. Effectively, they were trying to bring the law up to date with modern relationships and arguing that equity can only arise when no benefit, direct or indirect, is received from any loan. Mrs. Onyuru argued that no presumption had even been applied in this case, and in fact the decisions below had arisen on an assessment of the facts of the case as a whole. The judgment takes a deep dive through the history of the equity, much as Jamie has just done, and sets out an 8-point distillation of repetitu, which is a very useful reference point. The judgment also goes on to consider some, at the time, recent cases in 2014 and 2015. In re Chorda, it was found that Mrs. Chorda was not entitled to rely upon the doctrine of the equity of exoneration. It was a similar set of facts. Mr. and Mrs. Chowder were married, they owned the family home together. A loan was secured over their joint property for use in a business by Mr. Chowder and his brother. That investment was used to buy property, which was turned into flats, and then remortgaged. The money from the remortgage then went to Mr. Chowder and his brother, but also payment was made to Mrs. Chowder. Again, the property was remortgaged and the sums were paid to a business in which Mrs. Chowder was the sole director, and about £70,000 were used to pay for joint family expenses. Now, Chief Registrar Baster found that the facts of this matter were very similar to repetitu. In particular, Mrs. Chowder worked for her husband's family business. They shared a bank account, and in her oral evidence, she referred often to our affairs. Chief Registrar Baster set out, "It seems to me that in the circumstances in which a husband and wife operate as the Chowders have, pooling their earnings and profits, administering their financial affairs jointly, and enjoying together a prosperous life, if not an extravagant one, such as that of the Pagets, it is as unattractive as it is artificial for one of them to seek to take the benefits, while at the same time seeking to enforce an individual right, in one respect, only to the disadvantage of the other spouse, or in this case, his creditors." Now, in the judgment in Armstrong and Onyuru, Lord Justice David Richards, in comparison to repetitu, set out, Although in his judgment in Re Chorder, Chief Registrar Baster said that the similarities between the Chorder and the Pitatu families were clear, the result of the two cases was significantly different. In respect of the liabilities of the husband's businesses, the equity of exoneration was implied in Re Pitatu, but denied in Re Chorder. Since there is no suggestion of a departure from Re Pitatu, and indeed the decision was binding on him, the different outcomes must derive from the close examination of the facts that the authorities require. It is clear that this is so from the recital of facts that led the Chief Registrar to his decision. He found that Mr. and Mrs. Chorder operated as one, and that, like Mrs. Paget, Mrs. Chorder referred to our affairs. It does appear to be the first case in which the equity of exoneration has not been available to a spouse as joint owner of a property, charged to secure a loan to the other spouse's business, but it does not mark a turning point in the law. It does not establish that the equity is not available simply where a spouse or partner can be said to derive an indirect benefit from the other's business, nor, despite the Chief Registrar's reference to them functioning as a family unit, like many or most modern families, does not mean that the equity is not available in the context of most modern married or cohabiting couples. Lord Justice David Richards then went on to consider the 2014 case of Day and Shaw. In this case, it was held that the wife was entitled to rely upon the equity of exoneration. Again, this was a second charge charged over the family home. The charge in this case was a personal guarantee for a business that had been run by the daughter and the husband. It was found that the wife in this case had no involvement with that business. And when a creditor sought to enforce a charging order over the family home, the wife argued that the equity of exoneration ought to apply. Now, Justice Morgan set out that Mr. and Mrs. The husband and wife were sub-sureties for the charge that had been made in favour of the husband and the daughter. And so the wife was entitled to rely upon the equity of exoneration, having received no benefit from that loan. But in the alternative, the judge found that although the wife had a small shareholding within that business, it was found that the amount of the shareholding was insignificant enough to find that there had been no benefit received by her, and again, in any event, she would have been entitled to rely upon the equity of exoneration. The next case considered in the Armstrong judgment is Cadlock and Dunn from 2015. Again, it was found that the wife in this case was entitled to rely upon the equity of exoneration. The facts of this are that the wife decided to charge her beneficial half of the family home to secure a loan in order to give to her husband so that he could reacquire his half of the property from a trustee in bankruptcy, having been made bankrupt previously. Now, in this decision, it was distinguished from Re Chorder, in particular as whilst it was found that the wife had received some benefit, it wasn't comparable in the sense that those funds hadn't been spent on joint expenditure, but rather the benefit was that the wife could remain in her family home. And although this was a benefit, it was one incapable of financial valuation, and accordingly she was entitled to rely upon the equity of exoneration. Now, those three cases that were considered in Armstrong and Onyeru, the judge determined, and also in consideration of a number of overseas judgments, that nothing called into question the approach as set out in Re Pitatu. The judge then goes on to consider whether the law ought to be changed in line with Mr. Passfield's submission that the historical approach of the courts was fundamentally inconsistent with the relationship which spouses bear or ought to bear to one another in their family affairs in current times. Now, in a fairly definitive no, the judge sets out in the judgment, I start from the position that the equity of exoneration is part of the law relating to sureties, entitling the surety to relief as against the principal debtor, unless the evidence establishes a contrary intention or the circumstances of the case lead to an inference that the equity is not to apply. This is applied as much to cohabiting couples, married or unmarried, as much as it is applied to other owners. I am not persuaded that the law in this area should be changed to accommodate what is said to be the relationship between cohabiting couples in their family affairs in current times, still less what that relationship ought to be. Couples arrange their financial and family affairs in an infinite variety of ways. So having decided that Repeat 2 still very much was in effect, the judge turned to the matter in hand of the Mr. and Mrs. Onyeru. The judge sets out the question whether an indirect benefit is sufficient to displace the right to exoneration is applicable as between all debtors and sureties, although in practice, of course, the issue of indirect benefit is most likely to arise in the case of cohabiting couples. It is clear from the cases that English law has not regarded an indirect benefit to be itself sufficient to deny a right of exoneration to the surety. And the judge goes on to consider that any indirect benefit that Mrs. Onyeru had received from the continuing success of her husband's business based on the loan that the business received, this indirect benefit was a double contingent on both the business surviving and then the business being profitable. And thus, the judge found it was too remote in this case to infer an intention to bear the burden with her husband. Now, the more recent case of Armstrong and Harrow, the judgment coming out in July of 2025, this has a very complex fact pattern, but I'll simplify it for the benefit of having to listen to the facts. In this case, the judge held that Mrs. Harrow was not entitled to rely upon the equity of exoneration. Now, the fact pattern is that these were, again, a married couple. They were joint proprietors of a family home. There were a number of loans secured over the family home, totaling approximately £600,000, and then another loan over a property that was held, that was owned by Mrs. Harrow only. Now, in 2020, Mr. Harrow was declared bankrupt, and the trustee in bankruptcy sought half of the proceeds of the sale of the family home. The loans in question that were secured over the family home were made to a business called Callian, of which Mr. and Mrs. Harrow were directors and shareholders. And the payments were made to discharge debts owed by a company called Watercare, which was owned solely by Mr. Harrow. Now, the facility was obtained by Callian, but the money paid directly to Watercare. Mrs. Harrow argued that she had nothing to do with Callian, despite being a director and shareholder. She had been pressured into granting the charges, and that she had received no benefit from the loans, and thus the equity of exoneration ought to apply. Now, the matter came before ICC Judge Mullen, and within the judgment, Judge Mullen sets out a very similar analysis as that which is set out in the case of Onyeru. What fell to be an important question within the Harrow case was whether the shareholding and directorship of Callian, as of Mrs. Harrow being a director of, was fatal to her claim for the equity of exoneration. Now, ICC Judge Mullen set out 7 steps in order to answer this question. The first being, there is a presumption as between co-owners of property that they intend that the burden of the indebtedness secured on the property should fall primarily on the share of that one of them who is the debtor. Secondly, if the loan is not made directly to one of the co-owners, but instead made to a company or other entity owned and controlled by him, he is treated as the debtor for these purposes, just as if the loan had been made to him personally. Thirdly, the presumption will be rebutted by an express or implied agreement as to the apportionment of the loan between the debtor and the other co-owner, or if it is shown that the other co-owner benefited from the loan. Fourthly, the exercise is not necessarily to determine who got the money, but to consider whether the other co-owner obtained the benefit, or at least a benefit, from the loan, but indirect benefits in the form of the financing of the co-owner's joint living expenses do not prevent the equity from arising. Where the loan is made to both co-owners as joint principal debtors, the presumption does not arise, and the default position is that they are equally liable. Consistently with the second point above, Where the loan is made to a company or other entity jointly owned and controlled by both co-owners of the property, then they should be treated as joint principal debtors, just as if the loan had been made to them both personally. And finally, the equity might nonetheless arise where it is shown that a co-owner's apparent joint ownership and control of a company arising by reason of their shareholding and directorship is in fact insignificant or illusory, so that they can be said not to have been the recipient of the benefit of the loan in that capacity. It seems to me that the onus must be on the co-owner to prove that this is so in order to justify a departure from the default position. And so ICC Judge Mullen found that it wasn't fatal to a claim that Mrs. Harrow had been director and shareholder of Callian, who'd had the benefit of the loan. But he did need to go on to consider whether Mrs. Harrow had no or no significant interest within that company itself. Now, on the basis of the facts, the court found that she did have a significant interest in the business, setting out not only was she a director, but she acted as such in the execution of documents, and she used the company's accounts for her own purposes. Mrs. Harrow accepted that she understood the obligations that appointment as a director entailed, and indeed she was a director of other companies independently of her husband. As a shareholder, she had direct financial interest in the company. To ask simply who got the money would ignore the reality that the loan was made to a company of which both Mr. Russell and Mrs. Harrow were the owners and the decision makers, and I am not satisfied on the balance of probabilities that Mrs. Harrow was unable to make decisions freely. It follows that Mr. Russell and Mrs. Harrow are to be regarded as joint principal debtors for the purposes of determining the existence of an equity of exoneration in relation to the loans to Callian. Of note, within Re Harrow, the judge was clear that although the shareholding and directorship of the company that received the benefit wasn't necessarily fatal, Mrs. Harrow's involvement and control over that company in this case was. There was also a consideration as to whether, because the monies that were secured by Callian were used to satisfy debts that were held solely by her husband, whether she had not received the benefit. But on that point, the judge considered that her ability to make the decisions about where the money went and whether that they were to be used to offset another company's debts was a benefit within itself. Again, a reiteration of the question who got the money is just not quite sufficient when answering the questions of whether the equity arises. Thank you.
Thank you. I'm now going to look at the principle of equitable accounting. So equitable accounting is a process whereby the court establishes the equitable entitlements arising in relation to jointly owned land. It is distinct from the role that the court plays when establishing the individual's proprietary interest in that jointly owned land, albeit that the shares identified by that process will be of considerable significance when the equitable account is drawn. From the perspective of the trustee in bankruptcy, and indeed any other co-owner of the property, the equitable accounting process will likely be relevant in recognising the value of the three following elements. First of all, an occupation rent payable by the remaining party. Secondly, recognition of contributions made to the property and for its eventual improvement. And then thirdly, mortgage contributions paid by the remaining party. It is the first of those elements which causes greatest controversy, and which I'm going to focus on here. The general proposition was stated by Lord Denning, MR, in the non-bankruptcy case of Bernard and Joseph's decision from 1982, and he put it in the following way. After ascertaining the shares, the next problem arises when it is to be turned into money. Usually one of the parties stays in the house paying the mortgage instalments and the rates and other outgoings. The house also increases in value greatly owing to inflation. None of that alters the shares of the parties in the house itself, but it does mean that when the house is sold or the one buys the other out, there have to be many adjustments made. The one in possession must be given credit for paying the other's share of the mortgage instalments and be debited with an occupation rent for using the other's share of the house. Other adjustments may be needed for other outgoings. Then the net amount must be divided according to the shares. The second of those items identified by Lord Denning, payment of an occupation rent, finds its origins in the concept of ouster, with it not being enough for a co-owner not to be an occupation. Something more was required. The point was made in this way by Mr. Justice Purchase in the family case of Dennis and MacDonald, again a 1982 decision. Only in cases where the tenants in common, not in occupation, were in a position to enjoy their rights to occupy, but chose not to do so voluntarily and were not excluded by any relevant factor, would the tenant in common in occupation be entitled to do so free of liability to pay an occupation rent. This approach was upheld on appeal by the Court of Appeal, Sir John Arnold, who held that what was required was something equivalent to the ouster by one tenant in common of the other. These concepts were formed in the context of conventional disputes between co-owners and were applied in the bankruptcy context by Mr. Justice Vinlott, sitting with Mervyn Davies J. in the 1990 case of Re Gorman. That case concerned a property that was jointly held by Mr. and Mrs. Gorman. Upon their divorce, Mr. Gorman moved out. He failed to make payment of the mortgage, and to avoid losing her home, Mrs. Gorman made those mortgage payments. On an application for possession and sale, the court accepted an entitlement to account for an occupation rent from the making of the receiving order on grounds that Mrs. Gorman could assert no right against the trustee to remain in exclusive occupation of the property. As to the period prior to that order, and whilst Mrs. Gorman remained in exclusive occupation, it was held that no entitlement existed, albeit that that was a decision very much on the facts of that case and in the context of a concession to that effect from the trustee. The issue of an entitlement to an occupation rent for the period prior to the making of a bankruptcy order was an issue in the case of In Re Pavlau, a 1993 case. As regards that issue, Mr. Justice Millett derived the following propositions. First, a court of equity will order an inquiry and payment of occupation rent not only in the case where the co-owner in occupation has ousted the other, but in any other case in which it is necessary in order to do equity as between the parties. Second, where it is a matrimonial home and the marriage has broken down, the party who leaves the property will, in most cases, be regarded as excluded from the family home so that an occupation rent should be paid. Third, that it is not a rule of law, or that is not a rule of law, that is merely a statement of the prima facie conclusion to be drawn from the facts. And finally, the true position is that if a tenant in common leaves the property voluntarily, but would be welcomed back and would be in a position to enjoy his or her right to occupy, it would normally not be fair or equitable for the remaining tenant in common to charge him or her with an occupation rent. The next case to look at is French and Barcham, which was a case where cohabitating joint owners of a property lived together within the property for some 3 years prior to a bankruptcy order being entered against the by then husband. Some 12 years after the making of the bankruptcy order and prior to the coming into force of the lose it or use it provision, section 283A of the Act, the trustee sought possession and sale of the property along with declarations. As regards equitable accounting, there were two principal issues of interest. The first was whether the regime was exclusively governed by sections 12, 13 and 14 of Talata, and the second was whether it was legally correct that the occupying co-owner should account to the trustee for an occupation rent. As regards the application of Talata to the exclusion of the well-established principles of equitable accounting, some support for such a view could be found in the decision of Baroness Hale in Stack and Dowden, where she had held in passing the statutory powers replaced the old doctrines of equitable accounting, under which a beneficiary who remained in occupation might be required to pay an occupation rent to a beneficiary who was excluded from the property. Reliance on that argument was rejected by Mr. Justice Blackburn and French and Bartram for the following reasons. First of all, Baroness Hale was addressing her remarks to a situation where both parties have a right of occupation. That was not the case in bankruptcy, where a trustee has no statutory right of occupation. Second, the interpretation of the statute suggested that it was not applicable in the bankruptcy context. And third, neither Stack and Dowden nor Murphy and Gooch, which had applied Stack in this context, were bankruptcy cases. In those circumstances, the judge applied the conventional equitable accounting principles, with that approach having been adopted in a number of subsequent decisions. In those circumstances, at least until the matter is determined by the Court of Appeal, it would seem that the better view is that it is the equitable principles and not the statute that will prevail in the bankruptcy context. As to the second issue, that is, whether it was legally correct that the occupying co-owner be charged an occupation rent, Mr. Justice Blackburn held that the touchstone was whether it would be unreasonable in the circumstances for the non-occupying party to take up occupation which fairness requires the occupying co-owner to compensate the other for the fact that one has enjoyment of the property while the other does not. And this led him to conclude that application of the principle will ordinarily, if not invariably, result in the occupying co-owner have to account to the trustee of the beneficial interest to which the bankrupt co-owner was formerly entitled for an occupation rent. Now, Blackburn Jay's analysis was doubted by Mr. Justice Snowden in the 2017 case of Davis and Jackson, who with some judicial diplomacy observed that, with respect to Mr. Justice Blackburn, I do not find this analysis entirely convincing. In arriving at that assessment, Mr. Justice Snowden observed the following 3 points. First of all, earlier authority made it very clear that the default position, when one co-owner is in occupation and the other is not, is that occupation rent is not payable. Second, Mr. Justice Blackburn's approach would have the result, as a virtually immutable rule, that an occupation rent should be payable, which would be to reverse the default position in any case involving a trustee in bankruptcy. And third, what was required was some conduct or feature that justified the Court of Equity finding that it was fair or just that such a rent be charged. With the above in mind, the judge held that the court had a broad equitable jurisdiction to achieve justice on the facts of any given case. Further, in doing so, the court would have regard to the position prior to the bankruptcy, including any agreements or understandings to which the non-occupying owner was a party before his bankruptcy, as well as the effect of an order for payment of rent from the perspective of both sides of the argument. It therefore follows that it is not the default position that a trustee in bankruptcy will be entitled to an occupation rent. Rather, the court will have regard to principles of fairness and justice in determining what entitlement to an occupation rent, if any, a trustee in bankruptcy will have. Most recently, in Khatib and Ali, 2022 decision, a non-bankruptcy case, the approach taken by Mr. Justice Snowden and Davis and Jackson was endorsed, with the Court of Appeal holding, first of all, the task for the court is to do broad justice between the co-owners and do what is fair. And then, as a matter of principle, the trustee should not be in a better position than the bankrupt co-owner, before finally observing that creditors may adequately be compensated as a result of a rise in the property market without the need for an occupation rent being charged. Drawing those threads together, there are perhaps 6 propositions or headline points that can be derived from the authorities that I've summarised. The first is that a trustee in bankruptcy may be entitled to an occupation rent, both for the period prior to the making of the bankruptcy order and also after the making of any order, depending on the facts of the case. Secondly, that entitlement may be set off against the value of any improvements to the property and any mortgage contributions that have been made. Third, there is no rule of law or practice that creates a presumption of an entitlement to occupation rent by a trustee. Fourth, what is required is for the court to do broad justice as between co-owners when regard is had to what is fair. Fifth, there is no closed list as to the factors that may prove relevant, but they include, first of all, prior agreements and understandings as between the bankrupt and their spouse, and secondly, any benefits received by the trustee, including any increase in value in the property as a result of a more buoyant market. And then finally, number 6, the applicable principles are the equitable principles and not the statutory provisions found until later, at least as far as the High Court is concerned, and subject to any decision to the contrary from the Court of Appeal. In conclusion, the clear-cut approach to the entitlement propounded in French and Barcham has been rowed back from, and a trustee will not be entitled to an equitable account as a starting point. However, when notions of justice and fairness dictate, seeking an account for an occupation rent may prove an effective way of enhancing a trustee in bankruptcy's entitlements and maximising their realisations in respect of a given property. Thank you very much for listening. I hope you found the talk helpful, and if you have any questions, please do put them in the comments box, and we'll do our best to answer them. We have a couple of questions about notes and slides. No slides. We as with all of these talks, we decided not to do slides, but I think between us, Jennifer and I, I'm sure can combine our notes and make those available on the website.
Certainly.
So, in the absence of any other questions, thank you very much indeed. And as I say, hope you found it interesting.
Thank you.